The committee will come to order. The pending business is H.R. 2091. Is there further discussion? For what purpose does the gentlelady from Missouri seek recognition?
I move to strike the last word, Mr.
The gentlelady is recognized for 5 minutes.
Thank you, Mr. Chairman. I'd like to thank my colleagues, both Mr. Poliquin of Maine and Mr. Ellison of Minnesota, for introducing this critical piece of legislation that would help ensure families and children receive the resources they need in growing up in today's society. H.R. 2091, the Child Support Assistance Act, of which I am a co-sponsor, would provide state and local child support enforcement agencies with the ability to obtain needed consumer reports on non-custodial parents in order to enforce child support orders. Analysis of census data performed by the Pew Research Center finds that a record 40% of all households with children include mothers who are either the sole or primary breadwinner. Out of those households, 63% are headed by single mothers. And the share of single mom households has more than tripled in the past 5 decades, from 7% to 25%. More and more, these single moms are struggling to pay their bills at the 15th and the 30th of each month, and continually they find that there simply is just too much month at the end of the money. Child support agencies and programs help provide the needed and deserved support that children and the parents that are taking care of them need to meet today's financial demands of raising a family. For instance, Missouri's child support program collected more than $571 million in child support and handled over 360,000 cases last fiscal year. This is critical support that has already been deemed as owed to the family and helps pay for important things such as groceries, school supplies, clothing, medical supplies, and any and everything else. Almost 61% of the children in Missouri's support program were born to unwed mothers, many of whom are struggling to make ends meet every single month. We must do everything we can to make sure that parents are held responsible for supporting the families that they have helped create. And we must give the proper agencies the ability to adequately track down these payments. While the current system is doing great work, it is clear that improvements can be made that would prevent non-custodial parents from being able to shirk their responsibilities and avoid payments. Furthermore, we must support all of the single parents out there and ensure that they receive the help they need in doing the heroic task of raising a family on their own. This legislation is a step in the right direction. I urge passage of this legislation and yield back the balance of my time.
The lady yields back. For what purpose does the ranking member seek recognition?
Move to strike the last word.
Gentlelady is recognized for 5 minutes.
Mr. Chairman and members, I share my colleagues' concerns about reducing the administrative burdens on child support enforcement agencies. I remain concerned about doing away with the notice provision that I believe is beneficial. H.R. 2091 would expand the circumstances by which child support enforcement agencies can verify a non-custodial parent's income and employment, but the proposal eliminates FCRA's notice provision for this purpose, a provision that's designed to keep the non-custodial parents appraised of attempts to obtain personal information, financial information, anytime it is requested. So, look, I believe that every member of this committee supports non-custodial parents paying child support. We support that. That's without question. What this raises is a question of fairness, and that is a notice to the non-custodial parents for 10 days before you can take action when you are inquiring about their financial situation, their personal finances. And it's just about fairness and saying, okay, we're checking into your finances. Do you have less money? Do you have more money? Et cetera, et cetera, et cetera. And within 10 days, we will make a decision about the information that we have found. But just to move to enforce an action without giving a person a fair and decent chance to know what you're doing and why you're doing it, I think creates concerns. And so I would ask for a no vote on this bill.
Gentlelady yield back. This is gentlelady yield back.
Or yield back the balance.
Gentlelady yields back. Who seeks recognition? For what purpose does the gentleman from Minnesota seek recognition? The gentleman is recognized for 5 minutes. Is the microphone not working?
It's been a pleasure working with Mr. Poliquin on the... Are we up? Hello, hello? Yeah, so it's been a pleasure working with Mr. Poliquin on the bill. I got involved in the bill when Minnesota Child Support Enforcement Agency contacted me and requested that I try to make it easier for them to establish and enforce child support orders. In my legal career, I've had occasion to work on this issue over the course of time, and became convinced that my state agency, when they find it unnecessarily burdensome to take certain steps to help kids get the money they need from their parents, I thought I'd take a look at the issue, and I became convinced that it may well be burdensome to send a certified and registered letter to each parent 10 days before pulling the parent's income and employment information from Consumer Reporting Agency. They also note, I'm speaking now of my local authorities, that they're not required to send registered letters if they call the employer, just if the employer uses a third-party consumer reporting agency. They said the letter requirement is expensive to administer and completely redundant, and the information they're pulling is for parents who already have a court order to pay child support. So for those reasons, I think that this may be a way to reduce the cost of local government and may well end up helping more kids get the money they need from their parents. So with that, I yield back, and I intend to vote for the bill.
The gentleman yields back. Who seeks recognition? Chairman recognizes himself to say this is a very important topic. I salute the gentleman from Maine for his leadership. I urge adoption. I yield back the balance of my time. There being no further discussion or amendments to the bill, the question now occurs on adoption and reporting the bill favorably to the House. Those in favor shall signify by saying aye. Aye. All those opposed shall signify by saying nay. In the opinion of the chair, the ayes appear to have it. The ayes have it. The bill, for what purpose, the gentleman from Texas seek recognition?
Mr. Chairman, I request a recorded vote.
Recorded vote has been requested. All those in favor of recorded vote shall raise their hands and be counted. A sufficient number having raised their hands, a recorded vote is so ordered, and pursuant to subsection C5 of Rule 3 of the committee rules, the vote on this question is postponed. Now pursuant to notice, I call up H.R. 3192. The clerk will report the bill which was distributed in advance.
H.R. 3192, to provide a temporary safe harbor from the enforcement of integrated...
Without objection, the bill is considered read and open to amendment at any point. The chair recognizes the gentleman from Arkansas, Mr. Hill, the sponsor of the legislation, for 5 minutes.
Thank you, Mr. Chairman. I want to thank Mr. Sherman from California for assisting on this straightforward and very common sense measure. This provides a temporary safe harbor until February 1st, 2016 from enforcement of the newly integrated disclosure rule that is being proposed by the CFPB under RESPA and Truth in Lending. This bill is a bipartisan bill. It's substantially similar to previous legislation in the House with 44 co-sponsors. There's a bipartisan bill in the Senate as its companion. And just for some brief background, the final rule effective was August 1st, 2015, and then was moved by the CFPB due to almost 300 senators and House members commenting that it was going to be too soon, too quickly, and people were not going to have time to properly test their computer systems to make sure that neither buyer nor seller was inconvenienced by this new rule. And due to an administrative error on the part of the CFPB, it was temporarily moved for implementation on October 3rd. So this legislation will move that to February 1st, 2016. And I want to thank Mr. Pierce also for his work on this matter. And again, my distinguished colleague, Mr. Sherman. And I will yield back the balance of my time.
Gentleman yields back. For what purposes, gentleman from California seek recognition?
And to strike the last word.
Gentleman is recognized for 5 minutes.
Mr. Chairman, I want to thank my colleagues, Congressman French Hill and Congressman Steve Pierce, for their collaboration on this important issue. On my side of the aisle and in my own approach, I have a tendency to go along with what the CFPB wants and to vote against most bills that would alter anything they're doing. But this is a case where even those of us who are generally supportive of the agency need to give them a little push in the right direction. This bill addresses the TILA-RESPA integrated disclosures, also called TILA form, or TRID form rather, that is used to close a mortgage to buy a house. And as the gentleman from Arkansas pointed out, over 250 members of the House thought that this process of adopting this new form was a problem and urged a change. We got a change, but not the change we were asking for, because what we were asking for is not a delay, but a shakedown cruise. You can keep the ship tied up at the pier for a couple extra months. You can even spend that time going through looking at it while it's at the pier. But until you take it out on the ocean and take it for a shakedown cruise, you don't know what little problems you got to fix. Now, as Mr. French pointed out, the CFPB did delay the implementation date. But that's not a shakedown cruise. And they delayed it not because they were listening to us so much as because there was a clerical delay over there and they have to comply with the Administrative Procedure Act. In any case, they delayed it. But why do we need a shakedown cruise? Well, before the magic implementation date, you have to use the old form. If the transaction's begun after that date, you must use the new form. So regardless of whether it's August 1st or October 3rd, you just start cold turkey using the new form. And the question is, should you face enforcement action? Should you face lawsuits if you don't know use the full form? This bill says yes, you will, unless you do your very best to comply with this in good faith. But if you try to comply with the new rules for this shakedown cruise period, and you give the consumer, you do your level best to give the consumer all the benefits of the new form, right there, effective October 1st to 3rd, just the way the agency wants. And there's a bit of a problem. But you tried your best. Under this bill, for this limited period of time, you don't face the lawsuits, you don't face the enforcement action. That's why this bill is important, to make sure that all of those who are engaged in processing loan closings and home closings are in the business, that you don't have the more scared and the smaller groups that are less confident of their ability to be ready to get it perfect on October 3rd, which is the first time they get to try to use it. You don't get them leaving the market. That's why this bill has been endorsed by the American Escrow Association, the American Land Title Association, and the Appraisal Institute. Those are the folks that have to handle the real estate escrow closing. And it's been endorsed, of course, by the Credit Union National Association, the Independent Community Bankers, the National Association of Federal Credit Unions, the home builders, and the realtors. This bill does not delay for 1 minute the new form. It simply says that for a period of a few months, if you do everything possible to implement the new policy, and you screw up in this way or that way, you're not going to be faced with the lawsuits or the enforcement action. This is a reasonable approach, and what we don't want to see is to have quite a number of the escrow companies and title companies that do the closings, especially the smaller ones, leave the market because they're not confident that their software will do the right job. This does not deprive a consumer of the new form for a single day. And I hope that it has support on both sides of the aisle. I yield back.
Gentleman yields back, who seeks recognition. For what purposes the ranking member seek recognition?
I move to strike the last word.
Gentlelady is recognized for 5 minutes.
Mr. Chairman, while I supported the CFPB's decision to provide for a restrained enforcement period, I believe that private liability works to ensure that regulated entities are diligent in complying promptly with the new TRID disclosures. We worked with our colleagues in a bipartisan fashion to urge the CFPB to consider a restrained enforcement period for the new TRID disclosures, and the Bureau responded. It is worth noting that RESPA and TILA already provide for a limited liability for disclosure-related violations. Lenders are not subject to any liability under RESPA for disclosure-related violations. Only TILA provides for a cause of action in connection with its disclosure requirements. And even under TILA, creditors are allowed to cure errors made in good faith, making this proposal quite unnecessary. Given TILA's approach to disclosure-related violations, private litigation rarely prevails under TILA, especially given the number of mortgages that the marketplace originates. The particular litigation risk associated with the provisions of TILA that are part of the new TRID rule has been overstated, as private litigants rarely bring actions that prevail under the provisions of TILA that are implicated by the new TRID disclosures. I again lend my full support to the CFPB's decision, but H.R. 3192 is unnecessary in light of the limited liability for disclosure-related violations under TILA and the steps already taken by the CFPB. I yield back the remainder of my time.
Gentlelady yields back. Who seeks recognition? For what purpose? Gentleman from Texas seek recognition.
I move to strike the last word.
Gentleman is recognized for 5 minutes.
Well, Mr. Chairman, I rise in support of H.R. 3192, the Home Buyers Assistance Act of 2015, and I commend Mr. Hill and Mr. Pierce and Mr. Sherman for a very thoughtful piece of legislation. You know, one of the things that, and I associate myself with the remarks of Mr. Sherman, which I don't do on a regular basis, but I do today because he made a very good point, is that this is a new system. And one day you're using the old system, the next day you're using the new system, and quite honestly, this has been a major undertaking. This was a very, I forget how many pages to this rule. I think it was nearly 1,000 pages or something like that, but it was a very large rule, and it's made a huge change in the settlement procedures. All of these systems now have to be integrated, and it's very important that these systems talk to each other, and that these, so that when they get to the closing, that they're in compliance with it. And so I don't know why that anybody would object to having a little grace period there to say, okay, we're going to see how this new system works. We're going to work out the bugs on it, and quite honestly, I would encourage the CFPB to be a partner in that and to be monitoring, where there are problems, because this is a ship that hasn't been tested, and so I am very supportive of it. I think it makes a lot of sense, and I would encourage my colleagues to support this.
Will the gentleman yield?
I yield to the gentleman, Chairman.
Thank you. And then this will be brief. I want to thank the gentleman from Texas for yielding. I just wanted to add my voice again, thanking the gentleman. First, the gentleman from New Mexico, who's been a real leader on this, the gentleman from Arkansas, who authored the bill, the gentleman from California on the other side of the aisle. This is a big change, and it's big enough to where CFPB, I assume in good faith, they messed it up themselves in the implementation. There's no reason there shouldn't be a modest grace period in trying to assure that ultimately people in the system trying to buy homes aren't disadvantaged. Again, it is reasonable, it is modest, it fits the situation, and again, I'm encouraged by the bipartisan support for this. I thank the gentleman from Texas. I yield back to the gentleman from Texas.
I yield to the gentleman from California.
I want to note the gentleman from Texas says that it would be good if the CFPB did this on their own. A letter has been signed by 250 members of the House, very bipartisan. A similar letter by 41 senators asking them to do just that. They have issued a press release that talks about restrained enforcement in code words that are supposed to make everybody's blood pressure go down. The problem is none of that has any effect on the private lawsuit, and you're really asking people who get a small fee for closing the most important transaction a family has, buying a home, not to pull out of this market, not to delay those home closings, not to rain on somebody's dream, because, well, you probably won't get sued, and if you get sued, the plaintiff won't win. And the fact is, that's easy for us who are not in private business to say, don't worry about it, you probably won't get sued. I think it's a lot better to say, during this break-in period, during this shakedown cruise, you won't be sued. And that'll make it easier for even those who are smaller, who don't have whole teams of programmers and lawyers to stay in the business during this initial period. And with that, I yield back to the gentleman from Texas.
Would the gentleman from Texas yield?
I will yield.
Thank you for that. I just want to echo from Mr. Sherman's point of view that people are nervous from a heartburn point of view on the liability. But also, this is, as you said, or Mr. Nagelbauer said, an 1,800-page bill and a complex computer change for a lot of these small companies. And they just literally are looking for enforcement relief definitively, since they didn't get definitive relief from the director's letter, to just go through some closings and not have one hiccup for one of the most important things you can do, which is have a happy buyer and a happy seller at closing. And I thank the gentleman for yielding, and I hope our members will support this bill.
I yield back.
Gentleman yields back. The ranking member seeks recognition for a unanimous consent.
To insert into the record opposition to this bill by the Americans for Financial Reform, California Reinvestment Coalition, Connecticut Fair Housing Center, Consumers Union, Corporation for Enterprise Development, Empire Justice Center, Homeowner Preservation Foundation, Housing and Economic Rights Advocates, Local Initiative Support Corporation, NAACP, National Association of Consumer Advocates, National Consumer Law Center, National Fair Housing Alliance, North Carolina Justice Center, and USPR.
Without objection. Who seeks recognition? Are there any amendments? There being no further discussion or amendments to the bill, the question now occurs on adoption and reporting the bill favorably to the House. Those in favor shall signify by saying aye. Aye. All those opposed shall signify by saying nay. In the opinion of the chair, the ayes appear to have it. The ayes have it. For what purpose the gentleman from Texas seek recognition?
Mr. Chairman, I ask for a recorded vote.
A recorded vote has been requested. All those in favor of a recorded vote shall raise their hand and be counted. Need a few more hands here. A sufficient number having raised their hands, a recorded vote is so ordered, and pursuant to subsection C5 of Rule 3 of the committee rules, the vote on this question is postponed. Now, pursuant to notice, I call up H.R. 1839. The clerk will report the bill, which was distributed in advance.
H.R. 1839 to amend the Securities Act of 1933 to...
Without objection, the bill is considered read and open to amendment at any point. The chair recognizes the gentleman from North Carolina, Mr. McHenry, to offer an amendment in the nature of a substitute. Does the gentleman have an amendment at the desk?
Yes.
We'll pause for one moment to have the amendment distributed.
It's already been distributed.
I'm sorry, the amendment has already been distributed. The clerk will report.
Even better.
Amendment in the nature of a substitute to 1839. Strike all after the acting...
Without objection, the amendment is considered read and will serve as base text for purposes of amendment. The gentleman is recognized for 5 minutes.
Well, thank you, Mr. Chairman. I want to begin by thanking you, Mr. Chairman, for holding this markup and working through these issues with members and a number of great bills that we're bringing up today. I also want to thank the ranking member as well, along with the chairman, for working so hard in putting together this bipartisan measure we have before us. Ranking Member Waters and I have joined together in offering a federal exemption from registering for resales of private company securities, which is vital for adding liquidity to the secondary markets and driving economic growth. Today, private growth companies are not only disrupting existing industries, but are creating entirely new markets. Thanks to the private markets in particular, the advancement in American technology and entrepreneurship is thriving. Funding the growth of these private companies, however, has created a new paradigm shift that requires our regulatory framework to achieve a balance between encouraging innovation and growth while also ensuring that shareholder and investor protections remain strong. That's what our amendment does. Unfortunately, as successful entrepreneurs and startup employees look to sell their private shares in secondary markets, they encounter a regulatory framework that is inefficient. That's where our work is here today. Most private secondary transactions rely on a broadly accepted exemption known as Section 4.1.5. While widely known and applied, Section 4.1.5 has never formally been codified into securities laws. This is what our endeavor is to do today. The result has been a disjointed collection of case law and no-action SEC letters that have shaped these private secondary transactions. We don't think that's the efficient way for these transactions to occur. Our proposed amendment would help with this problem. The bill would provide an exemption for these types of transactions, allowing startup employees the ability to execute trades in a way that is consistent, clear, and certain. That's what our markets need. That's what the flow of capital needs. And it would allow for private companies to find a much better way to raise primary capital by opening up the secondary markets. Although the bill is a technical fix, we worked hard to seek compromise and to find common-sense solutions to this complicated exemption. And while we have negotiated a good working bill, my goal is to ensure that the language and operation of this compromise will work in the real world. I look forward to continue to work with the ranking member as necessary to ensure that this law is a useful tool and it serves as an example of how policy can meet the demands of a changing marketplace. The bottom line is that this bill is a sensible way forward. This bill will lower costs and provide a transparent standard for the issues that are important in private secondary transactions. Additionally, this bill will give today's private growth companies a foundation on which they can confidently plan their trajectory through the capital markets, both private and public. Ultimately, codifying this exemption will ensure that the United States remains the most accommodating market for the world's innovators to build their businesses. I'm pleased that this legislation enjoys support from my colleagues on both sides of the aisle, and I encourage and ask my colleagues on both sides of the aisle to support this bill. And with that, I yield back.
Gentleman yields back. For what purpose does the ranking member seek recognition?
I move to strike the last word.
Gentleman is recognized for 5 minutes.
Mr. Chairman, I'd first like to start off by thanking my colleague from North Carolina for his efforts to reach out to our side to find a bipartisan approach to more efficiently reselling private securities. He's done a great job in explaining this bill and laying out why it's so important that we all support it and endorse it. And while I'd like to take a lot more time, I'm trying to keep with your schedule of getting us out of here at 7 o'clock. So I support this bill, and I would ask my colleagues to please vote for it. Thank you.
Who seeks recognition? The chair recognizes himself for less than 5 minutes to say we are keeping to your schedule, not my schedule. But I will say this is common sense, this interfiliate swap provision, bipartisan. It should be supported by all members. I yield back. Who seeks recognition? There being no further discussion or amendments to the bill, the question now occurs on adoption and reporting the bill as amended to the House with a favorable recommendation. Those in favor shall signify by saying aye. Aye. All those opposed shall signify by saying nay. In the opinion of the chair, the ayes appear to have it. The ayes have it. The bill as amended is adopted.
And I ask for a recorded vote.
Recorded vote has been requested. All those in favor of recorded vote shall raise their hand and be counted. A sufficient number having raised their hands, a recorded vote is so ordered and pursuant to subsection C5 of Rule 3 of the committee rules. The vote on this question is postponed. Now pursuant to notice, I call up H.R. 3032. The clerk will report the bill which was distributed in advance.
H.R. 3032 to amend the Securities Exchange Act of 1934.
Without objection, the bill is considered read and open to amendment at any point. The chair recognizes the gentlelady from Arizona, Ms. Sinema, the sponsor of the legislation, for 5 minutes.
Thank you, Mr. Chair. Our regulatory system is inefficient, complicated, and confusing, which is why it's so important that outdated regulations are reviewed with the goal of modifying or repealing them to reduce waste and make them work for everyday Americans. This is why I've introduced bipartisan legislation with Congressman Hurt to repeal an unnecessary and outdated reporting requirement in the U.S. Securities and Exchange Commission. Since 1995, the SEC has been the only federal agency required to compile this obscure annual report. It is a waste of taxpayer dollars and a paperwork burden that diverts time and resources from protecting investors. Modernizing the SEC's reporting requirements will allow the Commission to better focus on its mission of protecting investors, maintaining fair, orderly, and efficient markets, and facilitating capital formation. I'm committed to working with my colleagues on both sides of the aisle to ensure that our financial markets work for everyone, and I hope that members will join me in support of this bipartisan legislation. Thank you, Mr. Chair.
Gentlelady yields back. For what purpose the gentleman for Virginia seek recognition?
Move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, I'd like to offer my support for H.R. 3032, the Securities and Exchange Commission Reporting Modernization Act. I'm pleased to be a part of this bipartisan effort to relieve the SEC of a reporting requirement that has not been imposed on any other federal agency since 1995, 17 years ago. Beginning in 1978, federal agencies were required to report the number of times each administrative body made a request of an individual's financial records. In 1981, the SEC became subject to this requirement, and subsequently this reporting requirement was repealed. However, because the reporting requirement was codified in the 1934 Exchange Act, the repeal measure did not have the jurisdiction to lift this burden off the SEC, despite the intent of the legislation. Since 1995, the Commission has been compiling these reports, even though they have not statutorily been required to report them. Today, because the SEC is still required to compile these antiquated reports, they have been publishing them online. Relieving the SEC of this compilation requirement will allow the Commission to better focus on its mission without in any way jeopardizing investor protection. In fact, in a 2013 letter to the House Financial Services Committee, SEC Chair Mary Jo White, along with all 5 commissioners, requested that Congress relieve the SEC of its obligation to compile these reports. This common-sense bill that Ms. Sinema has put forth today will do just that. I'm happy to have offered this measure with my friend from Arizona. I ask my colleagues to support this bipartisan measure and yield back the balance of my time.
Gentleman yields back. For what purpose does ranking member seek recognition?
Move to strike the last word.
Gentlelady is recognized for 5 minutes.
Thank you, Mr. Chairman. It is my understanding that this bill addresses an oversight in the law and relieves the Securities and Exchange Commission from an unnecessary administrative burden. Correcting this oversight for our nation's already overburdened Wall Street regulator will enable the SEC, which has specifically requested this change, to direct the saved time and staff resources to additional examinations and enforcement. I support the bill. Thank the sponsors for working together in a bipartisan fashion to address the issue. I yield back the balance of my time.
Gentlelady yields back the balance of her time. Who seeks recognition? There being no further discussion or amendments to the bill, the question now occurs on adoption and reporting the bill favorably to the House. Those in favor shall signify by saying aye. Aye. Those opposed shall signify by saying nay. In the opinion of the Chair, the ayes appear to have it. The ayes have it. The bill is adopted and ordered and reported to the House. For what purpose, gentleman from Texas seek recognition?
Mr. Chairman, I request a recorded vote.
Recorded vote has been requested. All those in favor of recorded vote shall raise their hand and be counted. A sufficient number having raised their hands, a recorded vote is so ordered, and pursuant to subsection C5 of Rule 3 of the committee rules, the vote on this question is postponed. At the request of the minority, we will now recess.
Request unanimous consent to enter into a record North American Securities Administration Association letter in support of the previous bill.
Without objection.
1839.
Without objection. Now, at the request of the minority, we will recess the markup and reconvene tomorrow morning at 9 a.m. The committee stands in recess.
Thank you.